What are the legal issues involved with OpenAI's use of Studio Ghibli's artwork in order to help users generate Ghiblify type images? Hi, I'm Derek Fahey. I'm a registered patent attorney and trademark attorney with the Plus IP firm, and this is going to be a quick video on some of the legal issues related to OpenAI's use of the Ghibli images. So first off, there's kind of two paths we have to consider. The first one is really the content that's being ingested. So on one hand, Ghibli could potentially argue that, hey, you don't have permission to use our content, and we want a licensing fee for using that content in order to train your model. And OpenAI is going to argue that that use is actually considered fair use because we're only analyzing information to dissect the patterns of what you're doing in order to help users generate content that's in your style. And the style is not protectable, and because it's considered fair use and it's transformative enough that we're allowed to do that. Now, the courts have yet to decide that factor, and one of the interesting things is going to be whether the style is protectable. That's kind of somewhat of a nuanced topic. The style of something is protectable. That's where trademark law comes in. Trademark law prevents people from creating some sort of false affiliation. So, maybe Studio Ghibli can potentially argue that, hey, you're creating this false affiliation with us. You're allowing people to use the term Ghibli into the prompts in order to generate these images. You're allowing people to think that somehow OpenAI has some sort of paid affiliation with Studio Ghibli, when actually we don't have anything that's actually in writing, and we haven't given you permission yet. So certainly, Studio Ghibli could certainly argue that, hey, the use of allowing users to do that is creating some sort of trademark contributory infringement. This is a really interesting case. Style of something is very hard to protect. So for example, if you have a very simple minimalistic style, that's very difficult to protect because many other people have that style. But if you mimic a style of something like an impressionistic style, that's going to be difficult to protect. Now, on the output side, if you create something, you could certainly potentially prompt something or upload something to create an image that may infringe on existing Ghibli artwork or image. That could potentially be an issue. So, for example, in fact, in some previous cases that are currently existing against OpenAI, some of the plaintiffs have argued that that users are able to produce content they are able to produce content that infringes on existing content. And what OpenAI is arguing is that we have guardrails. OpenAI has guardrails to prevent that from happening, so it should not be an issue. And in the cases that it is an issue, it's the plaintiff's attorneys and the plaintiff, prompting hundreds of times in order to get snippets of things that could be infringing. Case in point, if you were to say, go on ChatGPT and say, can you produce the first 5 pages of War and Peace? ChatGPT has guardrails that it won't do that. It will basically prevent you from doing that because that producing that content will be infringing. In this particular case, what Studio Ghibli would potentially argue is that, hey, they may, the plaintiff's attorney, if they may file a lawsuit, they may say, hey, when I upload an image and I prompt it, you are actually producing an image that is infringing on my particular artwork. So the output is also infringing. And because that output is infringing, and because the style resembles the style of Studio Ghibli, it's infringing on our trademark rights. Very nuanced arguments. In response, ChatGPT is certainly going to argue that we have guardrails that prevent that from happening. I don't know how detailed their guardrails are, but it's really interesting to see this. Can the style of something be protected? That's potentially, I think, a route that may have some more nuanced arguments. That's the case. Can the look and feel of something be protected? And that could be protected under trademark law. So on the output side, you have potentially copyright infringement and also trademark infringement. On the input side, you potentially have copyright infringement and maybe even trademark infringement as well, because people are now using Ghibli in order to create some sort of false affiliation excuse me, there are people using Ghibli as a prompt to create some sort of false affiliation with Ghibli Studio. So hopefully you enjoyed the video. Really curious to see what happens next. If you have any questions, just reach out to me. And if you can, hit the like and subscribe button.